You kind of highlighted something too, Darren, like you should bring an attorney on as early as possible. Like, is that, like say, for example, I find a business, it looks really good. I submit a letter of intent or an LOI. Should I bring you on at that point or before that point, or what point should I be calling you up after I've found a business that I really like?
You know, it depends. Like, if you've got a really good relationship with your attorney and you trust his advice, and also he's not going to bill you for just kind of chit chat or idle chit chat, call him up, talk to him. And most attorneys are going to be pretty free with their time, especially at the beginning, if they know that, hey, if this soft deal goes hard, I'm going to be employed. He's going to take care of me. I trust him. He trusts me. For the most part, they'll be willing to kind of talk to you. And that's kind of what I would usually do, is say, hey, I've got something on the horizon. I'm going to sign an LOI. Can you take a look at the LOI and see if there's anything that are they being overreaching with their, non-disclosure statement? Are they being overreaching on, due diligence period? And then typically, as I said, most attorneys will do that. Any good attorney will do it for relatively cheap, right? And then when you get into the, hey, I'm actually doing full due diligence on this, then I would bring in the attorney. Some of the things that, and again, you've been buying lots of assets, which are different, right? But if you're buying an operational business, there are lots of things that people don't think of. Mainly, look at the supplier contracts with whoever's providing goods and services to that company. Most of them aren't going to care, right? Most of them aren't going to care if it's, Joe or Mike that's writing the check, as long as the check's written. But some might, right? And some might have a clause in their contract that says, this isn't assignable, and then you're going to have to go back to that same supplier and say, hey, can you give me the same deal that you gave previous owner? And maybe they say no, maybe they say yes, right? But these are some of the things that I think attorneys will kind of think of, at least an analytical-minded attorney, about contract rights and frankly litigation rights and purchase rights, to say, hey, have you thought about this? Do we have everybody on board that you need to be on board? Do you have all the employees on board? Is there a manager that you really need or want? And if so, get a contract with them before you enter into a purchase agreement, right? Contingent on you purchasing, because again, what you don't want to do is buy something and then realize that it's not what you thought it was.
Yeah, I've seen that too, where you have supplier concentration power or one or two employee power, where they know, hey, you just spent a ton of money on this business. And the supplier's like, okay, well, we had an agreement with the previous business. We don't with this one. Prices increased 20%. That might totally change the numbers of the business. Or I've also seen it. You take over a company and the general manager, 6 weeks in, comes in and says, hey, I built this company. I'm making X. I need to now make X plus 50% or something like that, So I think you could see some of that too, or, they'll end up leaving or whatever that might be. And then all of a sudden you're kind of stuck with this business that's pretty tricky. You bring the lawyers in because they're going to think about these things. Whereas the entrepreneur is like, hey, I can grow this thing so fast, and they don't look at the downside. Whereas you come in there and say, well, you could do the upside, but also maybe factor in this part and this part, or, if this person is so key, can you give them some small piece of equity or some profit sharing to kind of keep them in the place? And you're basically structuring a deal so that you're also covering your downside if things were to not go as smooth as every entrepreneur wants them to be or believes they're actually going to be.
Exactly.
What are some of the actual questions that, someone who's looking to acquire a company would be asking an attorney, like during the transaction?
Well, the biggest thing is just making sure that it's documented properly, right? And I think that's where most people think of attorneys, right? Is how do I document this sale so that the buyer's not going to go, Joe's Garage, you buy Joe's Garage, and then Joe opens up a garage right next door and calls it Joe's Garage 2.0, right? How do you How do you document it so that you're trying to limit as much risk as possible, right? And some, and that's a good and a bad. I have some clients that, you know, want purchase agreements that are so tight and so foolproof. And despite what you hear on the movies and the TV shows, there's really no such thing, right? And furthermore, the cost of drafting something like that just gets prohibitive. So, I mean, there is with any transaction, there is a step of faith that must be made. But I think it's an attorney's job to make sure that the entrepreneur has enough information to make that step of faith, right? And that's either through, and again, I kind of break attorneys' jobs on this is to either help with the due diligence to try to see if there's any potential risks that you're not thinking of, and then B, documenting the sale in the appropriate manner, right? And then and let me kind of move off of that onto a different thing, right? Some of the things that I hear a lot, most questions that I get are, do I need to create a new LLC to buy the asset? Right? That's something that I get a lot of time. Or what's the structure that I need to get? And again, I mean, look, it all depends. If this is a large company, you probably need to pull in. You probably need to pull on a financial advisor, and between the financial advisor and the attorney, they can kind of figure out what's the best structure for you from a tax situation and from a liability situation. In my opinion, your basic, I'm buying this asset or I'm buying this company, a simple LLC is going to be just fine.